Corrections will come to order. The clerk will call the roll.
Chair Harless.
Here.
Vice Chair Jones.
Present.
Dr. Allen. Harrison. Lowe.
Here.
Lozano. Meza. Here. Schatzline. Wharton.
Here.
A quorum is present. As a reminder, anyone wishing to testify before this committee today, please register at the kiosks in the hallway behind the hearing room. If you require assistance in registering or testifying, please get in touch with our committee staff. Josh, right up here in the front, can help you. During public testimony period, you will be limited to 2 minutes per witness to accommodate all those who wish to testify. For those who are unable to testify in the allotted time frame, your registration position will reflect in the official record. As a reminder to the committee and our visitors and witnesses today, the House Committee are subject to the same rules of decorum that govern the House proceedings. Signs, placards, or other objections of similar nature are prohibited. Food or drink are prohibited in the hearing room. Under House rule, committee members must first seek recognition from the chair before speaking for any purpose. All questions and remarks from members and witnesses must be limited to the content of the bill, the committee substitute, or other matters under consideration. The chair appreciates everyone's cooperation in preserving decorum. With that, let's begin. Members, we're going to call up pending business for votes on bills that we heard earlier. The chair lays out as pending business House Bill 1515. Members, this is the bill we heard previously that is the TDCJ sunset bill. The chair offers up a committee substitute. Is there any objection to the adoption of the committee substitute? The chair hears none. The committee substitute, the chair moves that House Bill 1515 as substitute be reported favorably to the full House with recommendation that it do pass and be printed.
And the committee substitute was adopted.
And the committee substitute is adopted.
Okay.
The chair will call the roll.
The clerk.
I'm sorry, the clerk will call the roll. We were here late last night. The clerk will call the roll.
Chair Harless.
Aye.
Vice Chair Jones.
Aye.
Dr. Allen. Harrison.
Aye.
Lowe.
Aye.
Lozano. Mesa. Schatzline. Wharton.
Aye.
6 ayes.
There being 6 ayes
3
and
absent.
3 absent, 0 nays, the motion prevails. This one?
24.
Yep. The chair lays out Senate Bill 2405. Members, this is TDCJ Sunset Bill companion to House Bill 1515 we just passed. The chair offers up a committee substitute. Members, the substitute aligns with the Senate with the House bill changes. It is exact language. Is there objection to the adoption of the committee substitute? The chair hears none. The substitute is adopted. The chair moves that Senate Bill 2405 as substituted be reported favorably to the full House with recommendations that it do pass and be printed.
Chair Harless.
Aye.
Vice Chair Jones.
Aye.
Dr. Allen. Harrison.
It is 2405 Senate Bill.
Yes.
Lowe.
Aye.
Lozano. Meza. Schatzline. Wharton.
Aye.
6 ayes, 3 absent, no nays.
There being 6 ayes, 3 absent, no nays, the motion prevails. The chair lays out as pending business House Bill 5639. The chair, Representative Jones offers up a committee substitute for House Bill 5639. Members, this is the bill we considered previously by Representative Garcia. The committee asked the author to work with TDCJ to address some of the members' concern, which she did. The committee sub incorporates input from TDCJ to ensure that it simply codifies the veteran housing program as currently operated by the department without creating additional burdens. Is there any objection to the adoption of the committee substitute? The chair hears none. The substitute is adopted. Representative Vice Chair Jones moves that House Bill 5639 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Harless.
Aye.
Vice Chair Jones.
Aye.
Dr. Allen, Harrison, Lowe. Lozano, Mesa. Schatzline, Wharton. Five ayes, four absent, no nays.
There being 5 ayes, 4 absent, no nays, the motion prevails. Members, the committee unanimously adopted House Bill 2854 by Representative Anchia relating to the required approval for certain hospital visits as a condition for release on parole or to mandatory supervision for certain releases and to the hospital's liability for damages resulting from those visits. Vice Chair Jones offers up the committee substitute for House Bill 2854 was reported from the committee. Is there any objections? The chair hears none. The chair lays, the committee substitute is adopted. The chair lays out House Bill 2854 as pending business. How come I got two of these?
No, you're fine.
Okay, okay.
We did a motion to reconsider.
All right. The Vice Chair Jones offers up a committee substitute. The only thing different with the committee substitute is it clarifies the liability and damage clause in the bill. The introduced bill said that the hospital would not be liable for damages under instances discussed by the bill, and the new language just clarifies that there are still some liable for things like gross negligence and other medical damages which are already in statute. Is there any objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. Vice Chair Jones moves that House Bill 2854 as substituted be reported favorably to the full House with recommendation that it do pass and be printed. The clerk will call the roll.
Chair Harless.
Aye.
Vice Chair Jones.
Aye.
Dr. Allen, Harrison, Lowe. Lozano, Mesa. Schatzline, Wharton. Six, five ayes, four absent, zero nays.
There being 5 ayes, 4 absent, 0 nays, the motion prevails. The chair lays out Senate Bill 1080. Members, this is the Senate companion to Chairman Cook's HB 3673 that we passed out of this committee unanimously. It relates to the revocation of occupational licenses from certain license holders and the issuance of a provisional occupational license to certain applicants with criminal conviction. The chair moves that Senate Bill 1080 without amendments be reported favorably to the full House with recommendations that it do pass and be printed. The clerk will call the roll, please.
Chair Harless.
Aye.
Vice Chair Jones.
Aye.
Dr. Allen, Harrison, Lowe. Lozano, Mesa. Schatzline, Wharton. Five ayes, zero nays, four absent.
There being 5 ayes, 0 nays, 4 absent, the motion prevails. Members, at this time, we're going to move on to new business. Do we have? All right, the chair lays out House Bill 3618 and recognizes Representative Kloxler.
Good morning, Mr. Chairman and members. Thank you so much for this opportunity. This bill has to do with invasive searches of female inmates within TDCJ. Currently, incarcerated women, who represent just 8% of the prison population, are often subjected to group strip searches as a condition of accessing routine programming like education, healthcare, substance use treatment, vocational training, and chapel services. These surges, developed for a predominantly male population, are not only ineffective at detecting contraband among women, but also have become a barrier to rehabilitation and re-entry programs. I'm going to stop there because I want to make sure that you guys have as much time as possible to hear from the witnesses.
Members, are there any questions for the representative? Okay. If not, we're going to call you, we're going to respect your right to close and call you up in just a moment, please. For those wishing to testify, please, we have to finish before 10, so 9:55, we're going to adjourn whether we're finished or not. So with that, the chair calls up Lori Mellinger. Good morning, ma'am. Please state your name, who you represent, and your position on the bill.
Good morning. Good morning, Chair, members of the committee. My name is Lori Mellinger. I'm testifying on behalf in support of HB 3618.
And are you representing
I
yourself?
am representing myself and Lioness Justice Impacted Women's Alliance, where
Okay,
I
you
am
may
chairman of
proceed,
the
please.
board. I was incarcerated at the Coleman unit, and I was released in 2015. About 5 years after my release, I went to work inside that same unit doing inside programming and reentry for a program called Empowering Women Out of Prison. I believe that gives me the firsthand knowledge of what life is like both behind the bars and coming back inside. The Coleman unit was better at programming than most, and from the outside, it always looked like a place of opportunity. But what visitors didn't always see, what no one really talked about when people were taking part in the programs, was the quiet and constant humiliation we endured based on strip searching. After classes, after rec, after working out in industry, we were always ordered to go inside strip completely naked in groups. We would hold our clothes in our hands, sometimes have to walk across a gym fully exposed under the eyes of the guards and under each other. There was no privacy, there was no dignity, and anything that could be seen as a flaw, a scar, a stretch mark, a tattoo, was up for judgment, ridicule, and shame, and not necessarily from the other women, but from the guards. I grew up in a very modest household, and being stripped like that in front of strangers was devastating. It's hard to revisit those memories even now. The damage was real, and it was never about the safety. We were told that these searches were necessary for security, but in all my time, I didn't see dangerous contraband. I saw notes, I saw stamps, I saw pieces of comfort, but I never saw a threat. The real harm wasn't from what the women carried. It was from what was taken from us, our dignity, our privacy, and our sense of health. This is a critical step forward, and it limits group searches to true emergencies, requires female officers, and promotes humane and less invasive practices. I urge you all to pass this bill.
Thank you for being here, and thank you for your testimony. Hang tight. Let's see if there's any questions for you.
Whoops, I just walked off.
Representative Lowe, for what purpose?
Question.
You may proceed, sir.
Hi, thank you for coming to testify. So, and I'm not trying to discount your experiences when I ask this. I went to the Coleman unit probably a month ago, and I was blown away at how efficient it was. However, you know, when we walked over to the industry area and we came back into one of the big rooms, and I'm just asking this from a logistical standpoint. I understand the privacy concerns. However, there's not enough guards, and there's also not enough, I think, individual spaces in order to conduct such strip searches. So I'm asking, do you think that there's a logistical issue here with the strip searches?
Thank you for that question. When you asked me that, I took myself all the way back to when I did work at industry. And I remember as you go through that breezeway, if it's still there. It's been a few years since I've been there. You walk into a room, and it was in that tiny waiting room where we were stripped, right there. That was also, you walked further, and it was the chow hall. And so, I mean, staffing is always an issue. I can tell you why I believe staffing is an issue at that particular unit. And I'm sorry, y'all, that's because it's a private facility and the pay is less. And it's hard to make a living around Austin, Texas, isn't it? So that is in and of itself another issue. But I believe that there are ways to mitigate that. I worked second shift. I know first shift is typically full, but there is that dedicated room where we eat, unfortunately, and multi-purposing that to kind of bring them into that little area as you're walking in could allow for a modicum of privacy, I think.
Okay, I do generally support this idea. My only concern is what are the construction costs? What other necessary measures will be taken to ensure that compliance with this? So I appreciate your time. Thank you.
Sure, thank you.
Members, any other questions? If not, thank you for being here. You're fine, thank you. At this time, the chair calls up Jennifer Toon. Good morning. Please
Good
state your
morning.
name, who you represent, and your position on the bill, please.
Yes, sir. My name is Jennifer Toon. I represent SELF and Lioness Justice Impacted Women's Alliance, and I am in support of this bill. I'll keep it real short and sweet. I was incarcerated almost 20 years. Our organization hears from over 500 women. So when we say that, oh, well, you were incarcerated a few years ago, things have changed, we still hear from members on the inside all the time. Men and women are different, and our levels of contraband and the level of security threat is just different. We would hope that TDCJ would be able to show the data on what type of contraband is found at women's units versus men's units. I haven't really been able to find that type of data to really piece out what kind of contraband we're talking about. In my 20 years in being strip searched, just like Lori said, I never saw these dangerous items during a strip search. So we are in support of this bill. We understand that strip searching is necessary. We would just like to make sure that women are treated with dignity and humanity when these procedures happen.
Members, any questions? Chair recognizes Representative Lowe.
Hi, good morning. Thank you for coming. So, I read a lot about contraband, right? And most of the time, admittedly so, it is male inmates. But from your time incarcerated, who brought in the majority of the contraband?
Oh boy, you're coming with good questions today.
Sorry.
Yeah, no, it's
I
great.
care.
The majority of contraband comes from staff. You ask any incarcerated person or formerly incarcerated person, they're going to tell you that it comes from a staff. And so when we see things like strip searches or mailroom policies being changed to combat contraband, while that may happen then, right, the majority of it comes through staff. And oftentimes, the influx that we have seen, K2 and other drugs start to infiltrate women's facilities, which is shocking because I never saw that in 20 years. Often, yes, it is coming from staff and from male staff, from our members, being able to use that as a way to, get vulnerable women to participate in things with male staff. So the contraband comes from the staff, from our lived experience.
Yes, and then also, I just have to ask a side question. Were you ever strip searched within the presence of a male?
Absolutely. Right, and that's by policy not supposed to happen. And I think maybe that's kind of sometimes when we try to talk to the agency about it, they see policy, we see practice. And so oftentimes we were stripped in these big areas where male staff could walk by or see. Sometimes the bus driver, even though it's not supposed to be a male bus driver on the medical transport bus. Yes, it happens.
Okay, thank you.
You're welcome.
Members, any other questions? If not, how long have you been out?
How long have I been out? I have been out almost 6 years.
Good for you.
Thank you.
Thank you. Congratulations.
Thank you, sir.
At this time, the chair calls up Emily McDonald. Good morning.
Good morning.
Please state your name, who you represent, and your position on the bill, please.
My name is Emily McDonald. I represent myself, and I'm here today in support of House Bill 3618. I was incarcerated for 13 years, and I'm not here to demonize TDCJ. I was housed on 4 different units due to my HVAC certification, and I encountered many officers who were passionate about their job in keeping the prison safe while simultaneously helping inmates to rehabilitate and reenter society. Having participated in multiple Wyndham classes, vocational and college classes, I experienced firsthand the trauma, humiliation, and detrimental impact group strip searches can have on female inmates. While participating in Culinary Arts Vocational, I was strip searched as a group 4 times every day. My class of 16 inmates was led into a large, empty room and told to get naked every morning. The officer in charge refused to let anyone hold their clothes to cover themselves and would not begin searching until everyone threw their clothes in a pile on the ground in front of them. You could always pinpoint the women who would shy away and act nervous. Most of the time, these women didn't even attempt the class because they heard stories of what they would endure. The officer started on one end and went person to person with the squat and cough procedure before having us shake our clothes and move on to the next one. We did this when we arrived, when we left for lunch, when we returned from lunch, and when we left for the day. 4 times a day, 20 times a week, 480 group strip searches for the 6-month class. We did this regardless of whether we entered the kitchen area, regardless of the fact that all knives were tethered and tools were accounted for prior to leaving class, and regardless of the fact that there were bathroom stalls right next door where we could have been searched 3 at a time with some semblance of privacy. In the 6 months I was in vocation, no dangerous contraband was found. The contraband that was found included things such as a t-shirt that had another inmate's TDCJ number in the collar, chapstick, which we were not allowed to bring with us, and one time the officer hit the jackpot, finding a girl's Free World eyeshadow, which for female prisoners is probably the #1 major contraband, comparable to a weapon for a male inmate. Group strip searching is not necessary for the safety and security of the female prison system and creates an unnecessary traumatic experience for the women, oftentimes preventing them from taking classes that would aid in their rehabilitation. House Bill 3618 is a step in restoring dignity and encouraging programming for female inmates. Thank you for your time.
Thank you. Members, any questions? If not, thank you for being here. At this time, the chair calls up Marcy Marie Simmons. Good morning. Please state your name, who you represent, and your position on the bill, please.
Thank you. My name's Marcy Marie Simmons. I represent Linus Justice Impacted Women's Alliance and myself, and I'm for this bill.
You may proceed.
I'm going to keep this really short because key points have already been made. I spent 10 years incarcerated in Texas, most of my time on the Dr. Lane Murray unit. Similar to Emily, I worked jobs and took classes that required these group strip searches. I'm going to get really raw very quickly and just walk you through what that looks like as a female. If you're on your cycle, when you walk into the room where you group strip search, you take your clothes off at the door to get in line, and you remove your menstrual products in a group, standing in line, waiting to be strip searched. So you can imagine what that looks like. All the key points about humiliation have been made. I just want to say, if this procedure is about safety, they are failing miserably because during group strip searches is when we can get things through, because there are multiple women, multiple things going on, and a few officers. So if I want to send a kite to my friend, a note, if I want to bring in a frog or flower from working field squad, that's how we would do it during group strip searches, not during individual strip searches. They're just not secure. It doesn't make sense. Thank you.
Thank you for being here. Members, any questions? If not, thank you for being here. At this time, the chair calls up Sarah Reyes. Good morning. Please state your name, who you represent, and your position on the bill, please.
Good morning, Chairman and members of the committee. Thank you for this opportunity to speak. My name is Sarah Reyes. I'm with Texas Center for Justice and Equity. I'm the Youth Justice Policy Director, and I strongly support HB 3618.
And are you representing yourself as well, correct?
Yes, sir.
Thank you.
This bill reinforces our obligation to uphold dignity, transparency, and fundamental human rights within our systems. It addresses a persistent issue, invasive and often unjust searches that can re-traumatize women, many of whom have already been survivors of abuse. These practices not only cause harm, but also discourage participation in critical rehabilitation programs that are essential for successful reintegration. There's also no compelling evidence or data from TDCJ that shows routine visual body cavity searches during access to programming such as education, substance abuse treatment, or vocational training prevents any type of contraband or improves public safety at all. These programs are rehabilitative in nature and are critical to reducing recidivism. Subjecting women to invasive searches simply for attending these programs creates a chilling effect. It discourages participation and undermines rehabilitation, which should be a central goal of these systems. This bill still also ensures that visual body cavity searches may only be performed under urgent circumstances or when reasonable suspicion exists, which I believe is a clear enforceable standard that protects both security and the rights of individual in custody. I urge you to support this bill. It reflects the values of fairness, decency, and responsibility that Texans expect from these systems. Thank you for your time.
Thank you for being here. Members, any questions? If not, thank you for being here.
Thank you.
Members, we do have a resource witness, if any of y'all need one. Anybody need it? Representative Lowe, who do we have for the resource witness? At this time, we're going to call up Jennifer Cosby, Regional Director, Texas Department of Criminal Justice. Good morning.
Good morning.
Please state your name, who you represent, and your position on the bill, please.
My name is Jennifer Cosby. I am a Regional Director for the Texas Department of Criminal Justice, as testifying as a resource witness on behalf of the agency Bill 3618.
Thank you. Members, any questions? Representative Lowe, you may proceed.
Hi, good morning.
Good morning.
Thank you for the tour a couple of weeks ago at the Coleman Center. It was great. It was very eye-opening. While I was asking some of these questions and listening to some of these ladies talk about their experiences, I was thinking of TSA. We go through all of these screeners and all of this pretty cool technology. So I'm wondering, from an efficiency standpoint alone, would we be able to find some technology to put into some of these facilities instead of having to go through the strip searches? Do you know, have you guys looked into that?
Yes, sir. The agency has looked into that, and we are in the process of having those millimeter scanners placed in facilities.
Okay, so would those be able to actually eliminate the need for cavity searches?
Yes, sir, possibly.
Okay. Also, I see some of the contraband brought in by the males. I mean, it's amazing what they can bring in their bodies. But what about the females? I mean, obviously, most of the stuff they can also bring in, but do you see any statistical or any actual physical evidence that that there's a huge concern about female inmates bringing in contraband?
At this time, I do not have any statistical data. However, I have on other facilities that I have worked on
Okay.
during a search seen contraband.
I would like to just add that if we are able to implement this technology that into the prison systems, I would also like to see it where officers coming onto the shift would also have to go through it, because it's pretty clear that most of the contraband that comes in is because of TDCJ employees.
Yes, sir.
Thank you.
Members, any other questions? If not, thank you for being here. Is there anyone else wishing to testify on, for, or against House Bill 3618? If not, the chair recognizes Representative Troxclair to close on our bill.
Thank you so much, Chairman and members, giving each of these women who feel so passionately about this issue the time and respect to tell their stories publicly. And thank you, Representative Lowe, for your thoughtful questions. I wanted to respond to a couple things. My understanding is that we've already spent over $8 million installing scanners, and that according to a warden that provided feedback on this bill, that all of the prisons currently have some sort of technology that could be used for this purpose. I want to underscore also the expense that taxpayers spend to ensure that these women have access to rehabilitation programs. It's better for them, and it's better for society as a whole for them to come out, having participated in the programs that are provided to them within TDCJ custody, and yet being humiliated 4 times a day in this way certainly provides a disincentive for them to do so. This bill provides enough flexibility for strip searches to still be conducted if there are exigent circumstances, but also, very importantly, it makes sure that TDCJ does implement policies that say female correctional officers are used whenever there are unclothed female inmates. So I'm so grateful for your consideration of this bill. Ultimately, this restores dignity to the women who are working so hard to better themselves while incarcerated. Thank you so much.
Thank you. Members, any questions? If not, thank you for being here. Is there any objections? If there's no objections, House Bill 3618 will be left pending. Are there any objections? House Bill 3618 is left pending. Yep, got you. The chair lays out House Bill 4515 and recognizes Chairman Cook to explain his bill.
Thank you, Chairman Harless. Members, appreciate the opportunity to lay out House Bill 4515 this morning. Current law allows individuals to receive an order of nondisclosure, also known as ONDs, for certain offenses dismissed after successful completion of deferred adjudication on certain first-time misdemeanor convictions. An OND seals a person's criminal record from the general public, but differs from an expunction, as its information does remain available for certain law enforcement and other specific agencies. But right now, there are guardrails in place to permit access to the records sealed by an OND for law enforcement, as well as financial, healthcare, and educational institutions. And this bill does nothing to make any changes to those guardrails. We do have a committee substitute that will be submitting to the committee so that you can consider it before or at the time of vote. But the committee sub is based upon feedback from stakeholders and the governor's office, and is pared down significantly. I intend that the committee sub will be limited to state jail felony offense of possession of marijuana only. Everything else that's currently in the bill will be removed in the committee sub, and so that's really the gist of the bill. The bill lays out what the timeframes are under Section 4. It's eligibility after 5 years for both community supervision or conviction. Same procedure, and nothing's changed with regard to the party petitioning to the court to make that request. Be glad to answer any questions, and would like an opportunity to close when appropriate.
Members, any questions? The chair recognizes Representative Lowe.
Hi, good morning. Thank you for laying out this bill. So this non-disclosure, so if I were to go on one of the background sites, if this were implemented and after a certain period of time, if I were to go on one of the background sites and, pay for a background check, you're saying that it wouldn't show up, but if a police officer pulls me over, they will have access to see that information. Is that correct?
Yeah, that's fair, and other agencies, financial and
Yes.
educational agencies as well, but what you said is correct.
Okay, thank you.
You bet. Thank you, sir.
Members, any other questions? If not, we'll definitely give you your opportunity to close.
Thank you, Chairman.
Thank you. All right, at this time, the chair calls up Tara Tucker. At this time, the chair calls up Tara Tucker. Good morning.
Good morning.
Please state your name, who you represent, and your position on the bill, please.
Good morning. My name is Tara Tucker. I'm the Texas State Director for Alliance for Safety and Justice. I am representing them and myself, and we are in support of House Bill 4515. I want to thank Representative Cook for authoring this important piece of legislation and the chair and committee for hearing it. ASJ is a multi-state organization that aims to advance public safety priorities that stop cycles of crime, increase trauma recovery, and promote successful reentry. There are millions of Texans that have criminal records that keep them from achieving economic stability. In most cases, despite having served their sentences, the criminal record follows them for the rest of their lives. Old records shouldn't be a lifetime sentence to poverty, and we can change that by expanding access to petition-based non-disclosures. HB 4515 would create new opportunities for people to get back to work and overcome barriers associated with criminal records. Today in Texas, only certain first-time misdemeanor convictions are eligible for sealing. This bill would expand that to include state jail drug possession. It would also make it so that people could seal more than one conviction. So, for example, if someone was experiencing addiction problems and had multiple arrests for that within a short period of time, if they had gone a long amount of time without getting rearrested and rebuilt their lives, this bill would give them the opportunity to have all of those arrests sealed. That's very important and would help a lot of people who had completely rehabilitated. We know that economic stability equals safety, so clearing a pathway to meaningful work for people with records is necessary to help them and it increase our workforce, reduce recidivism, and make our community safer. So With that, I'd be happy to answer any questions.
Members, Chair recognizes Representative Lowe, please.
Hi, good morning. So I guess I should have asked Representative Cook this question, but I'm reading this bill, and you know, a lot of the marijuana-related arrests include other charges. So I'm curious, would this bill be, would this law be enforced if you have not only some marijuana convictions, but you also have, say, some other petty theft crime, or do you understand what I'm saying? Because sometimes it shows a pattern. I think that if it's just marijuana, okay. But if it's marijuana and something else, then maybe we shouldn't just have non-disclosure. Just my thoughts, and I want to know your feedback.
I have a couple of thoughts. One is, under this bill, only the drug offense would be able to be sealed, so you'd still have a partial record. And I think that being able to see those patterns is important. Oftentimes, when you have someone who's convicted of drug offenses, you might also see theft offenses just because of the nature of addiction. I think that when you address that underlying addiction, you are addressing those other issues, and so it could be appropriate to then seal all of those things. But it would be an individual situation, and you'd have to look at each case, which petition-based non-disclosure allows for a judge to have that discretion.
Okay, thank you. I'm not exactly sure how I feel about this yet, but that's why I'm asking questions. Thank you.
Thank you.
Members, any other questions? If not, thank you for being here. You always a joy. Great smile. At this time, the chair calls up Nikki Presley. Good morning. Please state your name, who you represent, and your position on the bill, please.
Good morning. My name is Nikki Presley. I'm the Texas Director and Chief of Staff for Right on Crime at the Texas Public Policy Foundation. We are in support of HB 4515. Thank you, Chairman and Committee, and I want to thank Representative Cook for bringing this bill. In 2015 and 2017, Texas enacted legislation to expand who can receive an order of non-disclosure. Since then, we've seen great outcomes with very little recidivism among the population who have received an OND under those laws. DPS did provide us data showing that 91% of those who received an OND under those laws have not had a subsequent arrest, and less than 1% have had a subsequent violent felony conviction. HB 4515 would build upon these previous reforms by allowing an individual convicted of a state jail felony drug charge, and then the committee sub is obviously marijuana, as Representative Cook laid out, to petition the court for an OND. And this petition process means that the OND is not automatic. Instead, the decision is left up to a judge and allows prosecutor input and objection. And I did provide y'all with a flow chart that kind of describes how the petition process works. And as Representative Cook laid out, ONDs are different from expunctions as they do not completely destroy the record. Law enforcement courts and over 30 agencies and entities still have access to that sealed record. The goal of this legislation is to keep public safety intact while also providing a second chance to those who have earned it and have successfully been crime-free for 5 years after completing their sentence, with the hopes of removing barriers for them to obtain quality employment and be meaningful contributors to our communities. Thank you for your time, and I'm happy to answer questions.
Little housekeeping, we show you registered as Nikki Presley, Texas Director, Right on Crime, Texas Public Policy Foundation. You're for the bill.
Yes.
Is that correct? Members, any questions? If not, thank you for being here.
Thank you.
Is there anyone else? We do have a resource witness if anybody needs it. If not, is there anyone else wishing to testify on, for, or against House Bill 4515? If not, the chair recognizes Chairman Cook to close on his bill.
Thank you, Chairman Harless. I do believe that this is an important criminal justice reform and a workforce development bill, and I would appreciate your favorable consideration. I'm happy to answer any questions, Mr. Lowe. This bill does nothing to change the misdemeanors with regard to the question you asked a while ago, and so there are basically all misdemeanors are eligible for an OND except those set forth in Section 106.041 of the Alcohol and Beverage Code in sections 4904, 4905, 06, and 065 of the Penal Code, and Chapter 71 of the Penal Code. So any misdemeanor except those provisions are eligible, and so that would be up to the judge, as Ms. Presley stated.
Chair recognizes Representative Lowe.
Okay, I guess I got fixated on the marijuana because that's something that we hear all the time, but, and let me just, I think I'm supportive of the bill. My question is assaults, right? Misdemeanors can be assaults. So would those also disappear?
I don't have the penal codes memorized, so I can certainly look those up and just, I'll shoot your office a message with regard to those. But I would think that they would be eligible. But before I told you yes, I would want to look up those specific provisions of the penal code.
Okay, because I was thinking about that and domestic violence, but, all right, thank you.
Thank you, Mr. Lowe.
Members, any other questions? If not, if there's no objections, House Bill 4515 will be left pending. Are there any objections? Chair hears none. House Bill 4515 is left pending.
Thank you, Chairman.
Thank you, sir. The chair lays out House Bill 1826 and recognizes Representative Bowers to explain her bill.
Thank you. Good morning, Mr. Chairman and committee. Thank you, Chair Harless, Vice Chair Jones, and members for the opportunity to present House Bill 1826 before you today. This legislation is a step forward in our ongoing efforts to ensure that our correction system operates with fairness, transparency, and a focus on the health and well-being of incarcerated women. HB 1826 aims to establish mandatory depression screenings for pregnant women and women who have recently given birth while in county jail or in the custody of TDCJ. This bill addresses the critical gap in mental health care for incarcerated pregnant and postpartum women, ensuring they receive proper screenings for depression during a vulnerable period in their lives. Mandatory depression screenings require that each inmate who is pregnant or has given birth in the preceding year be screened for depression at specific intervals. In the screening timeline, it establishes a comprehensive screening schedule once each trimester during pregnancy, once during the 6-week period after giving birth, and at 6 and 12 months after giving birth. The implementation requirements direct both the TDCJ and the Commission on Jail Standards to adopt rules and procedures to ensure these screenings are properly conducted. 1826 builds upon our previous work with HB 2044 for the 88th legislative session, which addressed the same issue. We have engaged with corrections officials, mental health advocates, and women's health organizations to develop this legislation. With the implementation of 1826, we anticipate earlier detection and treatment for depression in pregnant and postpartum incarcerated women, improved mental health outcomes for mothers and their children, enhanced standard of care within our correctional facilities, reduced risk of self-harm, and improved overall well-being for this vulnerable population. I would ask you respectfully give me the right to close, and that I'll answer any questions if there are any.
Thank you so much, and we'll give you your right to close. We'll call the first, members, are there any questions? All right, thank you so much. We'll give you a right to close. I want to call our first witness, Desiree Ingram. Before you begin, if you could, please state your name, who you're with, and your position on the bill.
My name is Desiree Ingram, and I'm here in support of HB 1826 on behalf of the Texas Women's Healthcare Coalition.
Okay, and we have you down as the Texas Women's Healthcare Coalition, Women's Health Policy Advisor.
Correct.
Wonderful. Okay, please go ahead.
So, TWHC, we are a group of over 75 healthcare, faith, and community-based organizations dedicated to improving the health and well-being of Texas women, babies, and families by ensuring access to preventative health care. In 2020, mental health conditions, including depression, were the leading cause in 22% of pregnancy-related deaths in Texas. According to the Texas Maternal Mortality and Morbidity Review Committee, every one of these deaths was preventable. And 85% occurred between 43 days and 1 year after pregnancy. Women in county jails face unique challenges, including limited access to healthcare and support systems. Without treatment, postpartum depression can cause severe emotional distress, hinder recovery, and increase the risk of self-harm or suicide, risks already elevated in correctional settings. HB 1826 will help address this by requiring regular depression screenings for incarcerated women during pregnancy and throughout the postpartum year. Early identification and treatment will ensure that mental health needs are not overlooked, providing critical support at a time when women are most vulnerable. Maternal depression can disrupt infant development and bonding. Early intervention improves emotional security and reduces the risk of developmental delays and attachment issues, even when mothers and infants are separated. Screening and treatment also support a healthier transition back into society and more stable family relationships after release. We respectfully ask for your support in passing this bill to strengthen families and build healthier communities across Texas. Thank you for your consideration. I'm happy to answer any questions.
We show you registered as Desiree Ingram, Women's Health Policy Advisor, Texas Women's Health Care Coalition, and you're for the bill. Is that correct?
Correct.
Thank you. Members, any questions? Chair recognizes Representative Lowe.
Hi, good morning. Thanks for coming out today. So I'm not sure if you can answer this question, but I figure I'd ask. Being incarcerated is probably a pretty depressive place to begin with. Do you have any idea what the current protocols are of screening depression aside from being pregnant?
No, I don't. Not at this time. I don't know.
Okay, I should have waited, but thank you.
Sure thing.
Thank you for being here.
Thank you.
Members, I'm sorry, is there anyone else wishing to testify on, for, or against House Bill 1826? Please come up. Charlie, I show you registered. This screen doesn't show you registered, but okay, we got it now. We show you as Charlie Maloof, Texas Cure, and yourself, and you're for the bill. Is that correct?
Yes, sir.
You may proceed.
Good morning, Mr. Chairman, Vice Chairman, distinguished members of the committee. My name is Charlie Malouf. I'm formerly incarcerated. I'm representing myself, and I'm the Vice President of and representing Texas Cure. Our constituents include the approximately 11,000 women incarcerated in the TDCJ, and we are for House Bill 1826. The Texas Government Code 501, Inmate Welfare, Subchapter B, addresses mental health conditions. However, it does not go far enough to address the government's responsibility ensuring identification, safety, and treatment, initial and ongoing, related to housing, nutrition, hygiene, and depression of women prisoners who are pregnant or who have given birth within the previous year. Another missing requirement is the continuity of care during and after transfer from a county jail to TDCJ. Approximately 1/3 of the women's jail prison population suffers from some form of depression. These stressors not only affect the woman, but the child as well. Those in jail fall under more regulated oversight, while those in TDCJ suffer more significantly than those in the jails because of significant less oversight. Substandard foods, sustained lockdowns, denial of medical requests, bogus disciplinary cases, unreasonable or illegal denial of privileges, and other conditions deteriorate emotional well-being at a faster rate, causing mental health instability in the woman. Additionally, the level of depression compounded by the lack of mental health treatment, proper nutrition, and housing, such as segregation, create potential safety concerns for the inmate and the child and other inmates and staff. Properly treating them in jail, then neglecting them in prison creates a reckless disregard for the serious medical condition and inflicts cruel and unusual punishment. This bill focuses on jury instruction, mandated reasonable rules, and regulations with minimum standards for continuity of care, and provides essential legislative instruction. And for that, we ask your support.
Thank you, Charlie. Members, any questions? If not, thank you for being here. We always appreciate you. Is there anyone else who wishes to testify on, for, or against House Bill 1826? If not, the chair recognizes Representative Bowers to close on our bill.
Thank you, Mr. Chairman. Thank you also to one of my joint authors that is in the committee hearing, Representative Collier, for being here and for your support. I encourage any of you to sign up if you wish to support me in this. And Representative Lowe, if you'd like to continue the discussions on the floor, I'd be glad to do that. I had forgotten how early correction starts in the morning since my freshman session, but thank you for the opportunity to lay this bill out. And with that, I close.
Thank you for being here, Representative Bowers. Any questions? Chair recognizes Representative Lowe.
So thank you for laying out this important bill. You know, mental health is rampant already, and I'm sure it's much worse and while you're incarcerated. My question would be, shouldn't we already be doing depression screenings quarterly or every so often, that we wouldn't actually even need this bill?
Well, the fact is we are not. So that's why I am here, and that's why I've refiled it again. This is the second time that I filed this piece of legislation. And I do think that it's an area and issue that we need to pay attention to, especially when we look at all the trauma that incarcerated women face, pregnant or not. So again, if you'd like to continue the conversation over a breakfast taco or something, I'd be glad to do that down on the floor.
You got it, and thank you for your work.
Thank you.
Thank you, Representative Bowers. Members, any other questions?
Thank you
If
so
not, if there's no objections, House Bill 1826 will be left pending. Are there any objections? Chair hears none. House Bill 1826 is left pending. The chair lays out House Bill 1969, and the chair offers up a committee substitute to House Bill 1969 and recognizes Representative Collier to explain her bill. Representative, if you were here earlier, I apologize for not calling you up sooner.
No, that's fine. I just got here not too long ago, and I had got to hear some great bills. Thank you, Mr. Chairman and Vice Chairman Jones, for the opportunity to lay out committee substitute to House Bill 1969. This bill is simple in design but powerful in impact. The committee substitute to House Bill 1969 would require that upon their release from a Texas correctional facility, individuals be provided with a license, a driver's license. It also seeks to reduce the fees associated with obtaining this document. Currently, the Texas Department of Criminal Justice is required to provide suitable clothing, civilian clothing, money in the inmate's trust account, some cash, and a personal ID. This bill would add a driver's license renewal. So the issue is, many people who enter into the prison system, they have a driver's license, but our license have to be renewed every so often. And if their time in the prison system exceeds that, comes up to that time period for the renewal, they should be provided the opportunity to renew their license. Now, this bill doesn't change any type of holds on their license. If they have a hold on their license for anything, they would not be eligible. But if they are eligible, this bill would provide that cover. This bill addresses a critical but often overlooked challenge in our reentry system, ensuring that individuals released from Texas correctional facilities possess the basic identification documents necessary to reintegrate successfully into society, specifically a driver's license. Now, I want all of us to consider something. How do you apply for a job, rent an apartment, or enroll in school without identification? The answer is you can't. And yet, that's the reality many face the moment they step out of a prison gate. We often talk about rehabilitation and second chances, but those ideals mean little if people are released into the world without the very tools required to function in it. Committee substitute HB 1969 would provide a process for inmates to renew their driver's license prior to being released from prison. Please know, this is not about just gaining access to documents. It's about removing barriers that lead people right back into that system. It's about giving them a real shot at stability, employment, and contributing to their communities. And it's also a matter of efficiency. TDCJ already works to assist individuals in obtaining IDs and other documents, but this bill would streamline and formalize that process, saving time and reducing confusion for both staff and individuals leaving custody. Furthermore, it reduces administrative burdens on reentry services, making the process more efficient for both the individuals and the state agencies involved. Providing basic documentation is not a privilege. It's a fundamental first step in breaking the cycle of incarceration. Committee substitute to House Bill 1969 doesn't just help people succeed, it helps Texas succeed. With that, I will request the opportunity to close and open for questions if there are any.
Thank you for being here. I love your bill. I've had the opportunity to tour some of the TDCJ facilities, and it's the best of my knowledge, they're currently doing that. But thank you for your bill. I think it's very important for people's success. Chair recognizes Representative Lowe.
Hi, good morning. I love this bill, but I have a question. I'm looking at it, the first page, it talks about cash in an amount and in the manner described. Are you talking about so they have their commissary accounts? So you're basically saying that we transfer that to a debit card and give them immediate access to their funds, or can you explain exactly what that?
Okay, sure. That's already,
Yes.
something that happens, they get cash, and let me see. I have to look that up. I thought it was $100, but I don't want to misspeak.
no.
Somebody that's, it says the inmate shall receive $50 on his release from the institution and $50 on initially reporting to a parole officer. I see we need to fix that too, because it says his, and it should say that person. But yes, so it's $100 total if they do both.
Okay, and then if the person did not have a license,
Driver's
then
license.
I guess it would just be their personal ID, but as long as they're provided with some sort of documentation.
Yeah, so, I mean, if they were able to drive before they had a driver's license, this bill, because, I mean, they got to get to work. A lot of people rely on personal transportation, and so we want them to have a valid driver's license. We don't want them to get, they have to comply with all the laws when they're released. And so being able, if they have to report to parole, this would be helpful for them to be able to reintegrate and just, have a fresh start.
I love this bill, thank you.
Thank you, Rep. You're welcome to sign on.
Members, any other questions? If not, hang tight. Is there anyone wishing to testify on, for, or against House Bill 1969? If not, the chair recognizes Representative Collier. Don't sit down.
Thank you,
To
Mr.
close on
Chairman.
your bill.
Thank you. I respectfully request your favorable support, and I close.
Thank you, Representative. The committee substitute is withdrawn. Is there any objection to the bill being left pending? Is there any objection? The chair hears none. House Bill 1969 is left pending. At this time, the chair calls up House Bill 2708 by Dr. Allen and recognizes Vice Chair Jones to lay out her bill.
Thank you, Mr. Chairman. May I present from the dais?
You may.
Wonderful.
Wait, you may.
Thank you. I'm presenting this bill for Representative Alma Allen on HB 2708. Currently, only those persons who receive a discharge and dismissal after successful completion of a deferred adjudication probation are eligible for an order of nondisclosure. House Bill 2708 allows for persons who are convicted of certain misdemeanor crimes to be eligible for an order of nondisclosure upon completion of their sentence, provided the person has no prior criminal convictions and that they have not been placed on deferred adjudication probation. This bill makes the eligibility for orders of nondisclosure retroactive to help more people access stable housing and contribute to the Texas workforce. House Bill 2708 expands eligibility for people to petition to the court for an order of nondisclosure for a certain period of time based on their offense. Mr. Chairman, members, I believe there are witnesses, and I reserve the right to close.
Thank you, Vice Chair. Members, are there any questions for Vice Chair Jones on Ms. Allen's bill? If not, we're going to reserve you the right to close. Is there anyone wishing to testify on, for, or against House Bill 2708? If not, the chair recognizes Vice Chair Jones to close on the bill.
Thank you, Mr. Chair. I close.
All right. Is there any, if there's no objections, House Bill 2708 will be left pending. Is there objection? The chair hears none. House Bill 2708 is left pending. All right, the chair lays out House Bill 2729 by Chairman Dutton. He's not here. I'm going to explain this bill. Members, House Bill 2729 simply prohibits the use of hearsay evidence in a hearing for a violation of conditions of release from the Texas Department of Criminal Justice. With that, I respectfully am happy to answer any questions and would like the right to close. Chair recognizes Representative Lowe.
Hi, I have a question.
You may.
I'm reading this, and evidence in a hearing for a person charged with a violation. What is the major concern here? Just not enough due process?
Just that it's, yes, and that it's hearsay evidence and there's no physical evidence. That's it.
Okay, thank you.
Thank you. Okay, at this time, the chair calls John Wilkerson, Texas Municipal Police Association, and we show you registered as against the bill. All right. We're showing him not testifying and against the bill. Is there anyone else wishing to testify on, for, or against House Bill 2729? If not, the chair recognizes Chairman Harless to close on Chairman Dutton's bill. I close. All right. If there's no objections, House Bill 2729 will be left pending. Are there any objections? Chair hears none. House Bill 2729 is left pending. All right. At this time, the chair calls up
Which one are we doing?
1021.
The chair lays out Senate Bill 1020 and recognize Chairman Harless to explain, I'm sorry, Senate Bill 1021 and recognize Chairman Harless to explain the bill.
Thank you, Mr. Vice Chair, and I'm honored to sponsor the Senate bill by Senator Huffman. Stocking is. Thank you, Mr. Chairman or Vice Chair, and I'm honored to lay out Senator Huffman's bill. Stalking is a serious offense that can escalate into more violent behavior and have long-lasting psychological impact on victims. Under current law, individuals convicted of stalking may be eligible for community supervision, which can leave more victims vulnerable to continued threats and intimidation. Senate Bill 1021 seeks to prioritize victim safety by making defendants convicted of stalking ineligible for community supervision. It also authorizes the Department of State Health Services to suspend, revoke, or deny emergency medical service certificates or license if personnel, providers, or affidavits have stalked related convictions or deferred adjudication. Additionally, the bill prohibits inmates charged with or convicted of stalking from contacting the victim or the victim's family in any way, either directly or indirectly by a third party, unless the correctional facility director has received prior written consent allowing the contact. These measures prioritize victims and enhance the safety within the essential health care services. I respectfully ask for the right to close.
Members, are there any questions for Chairman Harless? All right. Want to call Rachel Burrs. And so we have your Rachel Burrs with the Dallas Criminal District Attorney John Crusoe's office, and have you registered for the bill?
Yes, sir.
Thank you so much. Please continue.
Thank you, Chairman Harless, Vice Chair Jones, and members of the committee. My name is Rachel Burris, and I'm representing my boss, Dallas Criminal District Attorney John Crusoe, in support of Senate Bill 1021. I have 20 years as a prosecutor and am currently a felony court chief. I've handled every type of criminal case and have seen the real positive effects of designating a case ineligible for probation and its role in parole eligibility. Senate Bill 1021 adds stalking to the list of cases that are ineligible for probation from a judge. People who commit the offense of stalking rarely stop stalking their victims without criminal intervention. According to the Stalking Prevention Awareness and Resource Center, 1 in 3 women and 1 in 5 men have been stalked in their lifetime, and 11% of them have been stalked for more than 5 years. I have seen firsthand the truth in these numbers. The offender does this behavior for weeks, months, and years on end. Truly, we may never know how long an offender engages in this behavior because too many end with the offender escalating to an assaultive offense. A short stint in custody isn't going to deter the offender. Right now, the punishment is mathematically less than 2 years for a full sentence, even less if they received pretrial time credit. And by leaving this case out of the codification of cases that 42A.02 or .54 applies to, that is exactly what punishment for this offense looks like, shorter than a misdemeanor offense. Senate Bill 1021 prevents these short sentences. To bring home this need in our system, one particular case we prosecuted, in 2017, a victim reported the defendant for stalking to law enforcement. His behavior was typical to stalking: emails, cards, showing up to her job, and then to her home. He was criminally charged with harassment and stalking. He did not stop contacting the victim. Indeed, he listed her as his emergency contact to the leg monitoring agency. She pursued and received a protective order. However, he was not deterred. Contact continued for over 4 years while the case was pending. He sent more and more letters. Eventually, he was convicted and placed on probation. Yet, his worrisome behavior didn't end. In fact, he cut off his leg monitor while on probation and was subsequently revoked. He was given the maximum sentence of 10 years, which would place him out of custody in 2031, except his projected release date is within a few months. It is time we protect our stalking victims and send a clear message to perpetrators. Please support Senate Bill 1021. Thank you.
Thank you so much. Members, are there any questions? All right, thank you so much.
Thank you.
Is there anyone who wishes to testify on, for, or against Senate Bill 1021? If not, the chair recognizes Chairman Harless to close on the bill.
I close and ask for favorable consideration.
Thank you, Chairman Harless. If there is no objection, Senate Bill 1021 will be left pending. If there's objection, the chair is here none, and Senate Bill 1021 is left pending. Gotcha. The chair lays out Senate Bill 1610 and recognizes Chairman Harless to explain the bill.
Thank you, Mr. Chairman and members. Senate Bill 1610 is Senator Perry's bill, and I am the House sponsor. The Texas Civil Commitment Office operates a treatment and supervision facility for civilly committed sexual violent predators, and the agency has continued to encounter several challenges with the problematic clients that regularly hinder the effectiveness of the agency's treatment and supervision program. Senate Bill 1610 addresses the facility's safety and security, sex offender registration, and civil commitment process. Specifically, the bill clarifies that civilly committed clients are subject to increased penalties for new felonies that are committed to the facility, including assault on staff. Moreover, in recent years, several staff have been seriously injured by some of the civilly committed clients. Violence of threats or violence must be stopped, and this bill ensures clients face stiff penalties for assaulting staff. Senate Bill 1610 also ensures that every client is a registered sex offender, a loophole in the law that has prevented several clients from being required to register. I ask for the opportunity to close.
Thank you, Chairman Harless. Members, are there any questions? All right. Hearing none, we'll proceed to testimony. The chair calls Charlie Maloff. Thank you so much for being here. We show you as Charlie Madoff, registered with the law office of Robert A.
McLaughlin.
McLaughlin.
Yes, sir.
All right. Is that correct?
Yes, sir.
And yourself?
Yes, sir.
And you are registered against the bill?
Yes, sir.
All right. Please continue.
Good morning, Mr. Chairman, Vice Chairman, members of this committee. My name is Charlie Maloff. I am representing the law office of Robert A. McLaughlin, and I am representing myself, and we are representing Curtis Adams and multiple clients who are residents of the Texas Civil Commitment Center who are actually innocent of the crimes that got them there or who have been punitively and vindictively restrained at the center since 2015. We are against Senate Bill 1610. The Constitution unequivocally prohibits subjecting innocent individuals to arbitrary vindictive abuses of official power and deprivation of rights under the guise of legal authority. No justification can legitimize this fundamentally unjust and unconscionable bill, which undermines the very principles of fairness and justice. I have handed you a copy of Mr. Adams' filings regarding actual innocence in Bexar County. As his paralegal, myself and his attorney, Mr. McLaughlin, personally interviewed his victim. In a recorded statement, she confirms, "He did not rape me. It was not me. I keep telling people, but no one wants to listen." The Bexar County Conviction Integrity Unit, TICO, and MTC have been aware of this, in all probability, actual innocence since 2007, when Mr. Lete, Texas Civil Commitment Office, discovered that Mr. Adams was actually 17 years old and not 22 at the time of the alleged crime, and that he successfully passed his polygraph. Since then, TICO, led by Ms. Marcia McLean, has repeatedly and vindictively retaliated against Mr. Adams for maintaining his innocence, denying tier advancement, subjecting him to abuses of official capacity, denied procedural due process, denied release to outpatient therapy, being cut off contact with family members, and just yesterday, having his cell trashed for over a half hour while staff abused their official capacity by confiscating his legal mail and case file, even though they have been put on notice of his pending litigation for release, and now they are criminally obstructing justice, tampering with evidence, and a witness. Our law office represents multiple residents we believe actually innocent of the crime that got them into the center. They too are constantly being retaliated against, denied proper medical care, denied procedural due process, denied contact with the family, required to wear an ankle monitor, and more. We believe, based on personal interviews, case review, and more, that approximately 6% of that center population is actually innocent of the crime that got them there. In all probability, actual innocent crime, another, in all probability, actually innocent client was represented by an attorney who had stage 4 brain cancer and died days after the conviction. How can you effectively represent someone when your brain is being eaten alive? We also represent several of the approximately 140 residents who should have been put in outpatient treatment in 2015. Since then...
Thank you so much. Sorry to
Thank you.
interrupt you, but we have to cut
It's
short.
all right, I understand.
Appreciate it.
my
But thank you
written
for your testimony. Just want
and the-
members, you have any questions?
Thank you. Thank you.
All right. Thank you for being here. Is there the other ones going to be? Okay, there it is. Next, we have Lionel Hanks.
Good morning, Representatives. My name is Linnell Hanks, and I represent myself.
And we just to check before you get started,
I am
Linnell
against
Hanks,
the-
we have you registered as yourself and against the bill.
And against the bill.
Yes, ma'am. Please continue.
I urge you to vote no on Senate Bill 1610. The men housed at the Texas Civil Commitment Center, most of them all have already served their sentence and now been in civil commitment 10 or more years due to a diagnosed behavior abnormality, not because of new crimes. These individuals lack volitional control, which is precisely why they are at the treatment rather than in prison. Senate Bill 1610 would impose punitive conditions on facilities that is supposed to provide care and rehabilitation, not punishment. Turning treatment into punishment is not only inhumane, it undermines the legal and medical basis of civil commitment. Even more troubling is that many of these men are being denied the very treatment required for their release. Individuals placed in solitary confinement, often minor rural infractions, do not receive therapy, yet are still held to the same treatment-based release requirements. Some residents have worked hard, progressed in their tier levels, and turned in assignments only to have their therapist refuse or acknowledge or approve their progress. This creates a system where success is made impossible no matter the effort or intent of the individual. Furthermore, this bill raises serious constitutional concerns. It targets a politically unpopular group for harsher separate treatment under the law.
These individuals are often not mentally capable of responding to punishment in traditional sense, as their diagnosis involves an impaired ability to control their behavior. To impose a life sentence in practice, if not in name, simply refuses or being unable to engage psychiatric treatment is a violation of due process and deeply troubling precedent. Denying release indefinitely when a system itself blocks access to treatment ensures that they'll never
Thank you,
be
ma'am.
free again.
Sorry, we have to cut you off.
Thank you, sir.
But thank you so much for
Thank
your
you.
testimony. Members, are there any questions? Yes. Go ahead.
Hi, good morning.
Good morning.
So I had never heard of the Civil Commitment Commission until I got sworn in. And you mentioned impaired behavior. You know, some of these people are considered the most violent sexual predators. And there are people in the civil commitment that have been released. So they have been, a very small amount, but they have been released. So is it possible that the people that have not been released have not shown that they are capable of overcoming the demons?
Maybe some, but maybe not all.
So also, you said impaired behavior and, they
A
lash
behavior
out at
abnormality,
state or staff. So what's the other alternative? Putting them in a mental health institution? I mean, because it sounds like to me they're still not capable of surviving in society. Is that correct?
That is the purpose of the civil commitment. That is why they're in civil commitment, because they had deemed that they had a behavior abnormality, which is a type of mental condition, that they are there for treatment. They don't get enough treatment. The staff is short. They do the best they can with what they got, but they don't have it. They just don't have enough for that many men. They need more therapists. They need more psychiatrists. It's not working because they don't have enough to work with. The men don't have enough to do. If you lay idle too long, you lose focus. So therapy is imperative. So they should be in therapy, not once a week, not once a month, every day. They should have some kind of therapy. If not, with a one-on-one therapy, group therapy is every day, I think, or I'm not sure on the group therapy. But they need to have more therapy than what they get. And not just handed the assignment books and say, here, do your assignments, and then I'll get them back to you whenever. That could be a week, that could be 2 weeks, that could be 3 months. There's no road to release there. So they lose hope, then they misbehave. And then the security officers are not held accountable for anything. And they are the residents are the ones that are always getting into trouble, regardless if they're provoked or whatever.
Okay, thank you very much.
You're welcome.
Thank you. Any more questions? Thank you so much. Next, we have Amanda Brady. Thank you so much for being here. We have you registered as Amanda Brady, representing yourself and against the bill. Is
Yes,
that
sir.
correct?
Yes, sir.
All right, thank you so much. Please continue.
Members of the committee, my name is Amanda Brady, and I am in opposition of Senate Bill 1610. There are many issues with this bill, but I want to address the introduction of provisions that would permit the ceasing of contact with individuals deemed not beneficial to treatment. Family support plays a crucial role in the well-being and rehabilitation of the individuals undergoing treatment. Suggesting that a family be removed from having contact could be detrimental to one's treatment. But gentlemen and lady, this is a reality. It is my reality. I am forbidden from having any contact with my husband, who is currently imprisoned at the Texas Civil Commitment Facility. We cannot speak, write letters, or have visitation. The last time I saw my husband's face was January 8th, 2023. I cannot begin to explain to you what this has done to my life, the level of devastation.
Imagine if you were unable to speak to your loved one, your significant other, hold their hand, or see their face for years. This bill will further allow a state agency to terminate relationships between a person in treatment and the members of their family. This policy raises significant concerns, particularly regarding the unjustified separation of individuals from their families. This bill would give too much power to a state agency. I'm in opposition of Senate Bill 1610, and I'm pleading with you to be also.
Thank you so much. Members, are there any questions? Thank you very much.
Thank you.
Next, we'd like to call Clarence Brown.
Good morning.
Good morning. So we have you as Clarence Brown, registered as yourself and against the bill. Is that correct?
Yes, sir.
Thank you so much. Please proceed.
Ladies and gentlemen of the committee here, I am a formerly civilly committed person, released nearly a year ago from the Texas Civil Commitment Center. I am in opposition to the bill because of the fact that you already have a penal code in place. And at this point, they're asking you to make certain provisions to a penal code to a certain class of people. What is wrong with the penal code that you already have in place? This penal code is nothing more than something similar to Jim Crow laws, where you have for this people here and for this people here. People are already given 25 to life for having multiple offenses already start with, such as the people in the Texas Civil Commitment Center. So why is there another bill to be more difficult on a class of people? I am not for staff assault. I'm not for harming or hurting anyone else. I agree wholeheartedly that there's something that should be in place, something that should be done. But this is not the bill that's going to correct that problem. This place has not been what it's been said it is to be. The men there were placed there, and much of the evidence used against them was because of their behavior in prison, aggressive behavior, sexual deviancy. All these things were reasons why they were committed. To me now you say, well, we have to have another bill because apparently the penal code isn't working or the treatment isn't working. This is an indication to me that maybe the entity is not capable of providing the proper treatment and need to be looked at. Thank you very much.
Thank you for your testimony. Members, are there any questions? Mr. Lowe, for what purpose?
Questions?
Please continue.
Hi, good morning. Thank you for coming out today and giving your testimony. So my question to you is, you were able to make it out. What do you think made you successful enough to make it out, whereas a lot of other people are not?
I don't think that we should be comparing myself to others. I think that some of us have the ability in which to do certain things to enable ourselves on a different level as opposed to certain others. Prior to going to the Texas Civil Commitment Center, I had treatment already in prison as well as in the outpatient program with therapists that were more than capable of assisting me and helping me to see certain things and to move about in certain matters. At the Texas Civil Commitment Center, I did not have the same thing. Therapists coming in, I had 10 therapists while in that facility. And had it not been for the treatment that I had prior to coming there, I probably too would still be there.
Okay. Thank you very much.
Any more questions? Thank you so much. Next, we have Alicia Castillo. Good morning. We have you registered Alicia Castillo, representing the Texas Civil Rights Project and against the bill. Is that correct?
That's correct, yes.
Please continue.
Good morning. Thank you so much. My name is Alicia. I'm here to oppose Senate Bill 1610. I want to thank Ms. McLean and her staff for welcoming us to have conversations with the agency as the sunset review begins on the agency this interim. And so for us, the reason we're opposed is because while public safety is paramount, we fear this bill reinforces some of the issues of due process and transparency that we're already concerned with the agency. So I'll highlight again that individuals who are in TICO are folks who have served their complete sentence in TDCJ. They did their time. And so it's been determined that they should go to this treatment center, which again is housed within HHSC. This is not housed in a correctional division. It's meant to be a rehabilitative program. And we know from Supreme Court decisions that it's really important that rehabilitation programs don't operate as correctional facilities. They operate in non-punitive ways, right, as truly rehabilitative. And so some of the doubling down on some of the punishment and reinforcing that, we feel like it raises some constitutional concerns for us. I also want to note that we know that a lot of the guys, and we would love to get the data on this, but a lot of the guys who are there have intellectual disabilities. So there's some concerns with the disability due process issues here. So specifically to the bill, though, the mandatory consecutive sentencing and lifetime imprisonment that this imposes further diminishes opportunities for rehabilitation and meaningful reintegration for folks. And I just want to note, like, typically out here in the world, a third-degree felony would be a 2 to 10 year sentence. This bill imposes a minimum 25-year sentence for new felonies, and it creates new felonies that are only applicable to people who reside at TICO. So that's deeply problematic to us. Lastly, I'll just mention again, they're up for sunset next session, so we would urge the committee to learn more about the office prior to making such permanent sweeping changes that will really impact people for the rest of their lives.
Thank you so much. Members, any questions? Representative Lowe, for what purpose? Question. Please continue.
Good morning. Thank you for explaining it very clearly. Due process. What do you think? Do you think there's anything we could do to make it a more fair process? Because I understand the concern for the safety of the community. I also know that we're not supposed to have indeterminate sentencing here in the state of Texas. And so that's kind of where I'm teetering on which side I'm on this bill, because we don't have indeterminate sentencing. However, we want to protect the community.
Absolutely. I do feel like there are things that we could do to enhance due process. And so that's why I feel like, especially with the agency coming up for sunset next session, we're going to have the Sunset Commission, incredible staff, right, go through everything, create their report, share that with you, tell you where maybe some of these due process concerns might lie and what their recommendations would be to fix it. And then you guys will have the opportunity to do that next session, right? But this bill is kind of going beyond that extrajudicial process for sentencing people to 25 to 99 years to life. And it's just not necessary to do that at this point. I understand that we're deeply concerned about staff and want to make sure that the conditions in the center are such that we're not exacerbating issues of aggression or anything like that. So, yeah,
Okay.
I hope that answers.
Thank you
the
so
question.
much.
Thank you.
Thank you. Members, are there any additional questions? All right, thank you so much. Uh-oh. Next, we have Christian Budwine. Howdy, ma'am. We have you as Christian Budwine with the Texas Civil Rights Project and Against the Bill. Is that correct?
Yes, sir.
Please continue.
So I'm passing out an article that I read this semester. I feel like I'm still in school. This session that really highlights the issue of the current civil commitment process in the center. I didn't know about the process until this session. Every time I learn something new about it, my jaw is dropped. Like it's actually insane. But I really want to focus my testimony on the U.S. Supreme Court's decision that was mentioned earlier. So U.S. Supreme Court Justice Anthony has stated, the point is not how long a person who is civically committed should serve a criminal sentence. The concern instead is whether it is the criminal system or the civil system which should make the decision in the first place. The U.S. Supreme Court first upheld Kansas's civil commitment program in 1997, ruling that because the nature of that confinement was treatment-based and not punitive, it passed constitutional muster. In his concurring opinion, Justice Kennedy gave a striking warning to all states in saying if the civil system is used simply to impose punishment after the state makes an improvident plea bargaining on the criminal side, then it is not performing its proper function. We should bear in mind that while incapacitation is a goal common to both the criminal and civil systems of confinement, retribution and general deterrence are reserved for the criminal system alone. If civil confinement were to become a mechanism for retribution or general deterrence, our precedent would not suffice to validate it. If Justice Kennedy were to analyze what TCO would look like under Senate Bill 1610, I think he would conclude that civil confinement is being used as a mechanism for retribution and general deterrence. I do not make this assumption lightly. Pointing to the bill, two things that are really striking. The first is that if a person who is found guilty of any felony offense and is civically committed at the time of the offense, they must be transported back to CDCJ to serve 25 years minimum, life maximum. This means that a person committed to TCC would have to serve a life sentence for a simple assault. And I'll stop there. I had more, but we'll visit your offices.
Thank you so much.
Thank you.
Members, are there any questions? All right, thank you so much. Next, we have Connor Hanks. Oh, sorry, I got it right here. Good morning. We have you as Connor Hanks, registered as yourself and against the bill.
I represent myself. Please forgive me. I'm intellectually disabled, so please be patient with me, okay?
Not a problem.
My preferred name is Clark, but thank you. My name is Clark Connor Hanks. I have a brother in civil commitment. I'm asking you to vote no on Senate Bill 1610. My brother has already served his full prison sentence, yet he's been locked away for almost 10 extra years. He's been gone for most of my life. This bill would make it even harder for people like him to ever come home. And that's not justice, it's punishment beyond what law already imposed. Senate Bill 1610 is overly broad and dangerous subjective. Under its language, someone's freedom could depend on another person's mood or opinion. And that's not how our system should work. Anyone could wake up annoyed. That doesn't mean someone else should lose their chance of freedom. If you pass this bill, you're also saying that this civil commitment facility isn't capable of treating men with behavioral abnormalities. So why are taxpayers spending over $43 million a year to keep it running? Either it's a treatment facility or it's not. You can't have it both ways. Please vote no on Senate Bill 1610. I want my brother to have a chance to come home. I want to see my brother. I want to hug my brother. I haven't seen him since I was 9. I miss him. I'm sorry.
No, it's all good. Thank you so much for your testimony, and thank you for advocating for your brother and your family. Members, are there any questions? Thank you so much. Oh.
Connor, I just want to say you did a great job testifying. Thank you for being here.
Thank you. God bless you, sir. Thank you.
Connor, we show you as Connor Hanks against the bill. Is that correct? Yes. Thank you.
Next, we'd like to call Jessica Marsh.
Good morning, Chair Harless, Vice Chair Jones, members. I'm here as a resource witness available to answer any questions that you may have about the bill.
Thank you. Members, are there any questions? Representative Lowe.
Hi, good morning. You have a tough job. So when you're going from TDCJ to, say, TCCO, what assessment happens to determine that, hey, you can't go on parole, you need to go to this facility?
Sure. There is a lengthy review process that narrows down the field of individuals that are eligible for civil commitment prior to their release from prison. That goes along with an extensive due process that's afforded to those individuals. It starts 2 years prior to release, The Texas Department of Criminal Justice multidisciplinary team reviews every individual that has the two requisite convictions, the two contact sex offense convictions, to determine, are they currently serving a sentence for one of those convictions? If the answer to that is yes, then they're reviewed by the 7-member panel, a multidisciplinary team made up of professionals from a variety of fields to include sex offender treatment, mental health, our office, the Department of Public Safety, and 2 from the Texas Department of Criminal Justice to include victim services and sex offender rehabilitation programming. Those 7 members review each of those individuals to determine, does it appear that this person is likely to reoffend? If the answer to that question by a majority vote is yes, they go to the next step in the process, which is a full evaluation by a psychiatrist or a psychologist to determine if the individual has a behavioral abnormality, which is a condition, which is a congenital or acquired mental condition that affects their predisposition to commit future sex offenses. If the individual is determined to be likely to continue to commit future sex offenses to the point that they are a menace to the health and safety of others, then they move to the next step of the process, which is to be referred back to the district attorney for their last county of conviction for a sexually violent offense. That district attorney then gets the discretion to decide, is this a case we're going to file and move forward? If the case is filed, both the state and the person are entitled to additional evaluations. The individual that's being reviewed for commitment has an appointed attorney, or they can hire one if they choose to do so. And they go through additional evaluations, deposition, full trial with all procedural due process that's associated with that. It is a civil trial, but they actually use that higher burden of proof from a criminal trial. So the state has to prove at that trial beyond a reasonable doubt that the person meets commitment criteria.
Okay, if they could afford one, can an attorney be a part of this process for the inmate?
Yes, all of the inmates that are involved in this process do have an attorney representing them, whether that is an appointed attorney with State Counsel for Offenders or a hired attorney if they're able to hire their own attorney.
Okay, thank you for clarifying very simple terms. Also, are there special kinds of treatment programs that you would get at TCCO that you wouldn't get at TDCJ?
So the TDCJ does have sex offender rehabilitation programming, and they have a 4, 9, and 18-month program. And their program actually dovetails into our program so that the individuals who are civilly committed are able to begin their treatment while in prison and then continue that treatment upon release to our program.
Okay, what do you think about some of the comments about the constitutionality of this?
Sure. Constitutionality of civil commitment has been upheld both by the United States Supreme Court as well as the Texas Supreme Court, provided that the program's goal is rehabilitation, which it is in this instance, of working to rehabilitate each individual's behavioral abnormality such that they're no longer likely to go into the community and reoffend. The entire goal of the program is no more victims.
Okay, thank you very much.
Thank you.
Thank you. Any additional? Are there any additional questions? Oh, Chairman Hollis?
Thank you. How often do new offenses occur at the Texas Civil Commitment?
Sure. For several years, it was actually few and far between that we would have assaultive offenses among the clientele. But in the last several years, we have seen a rise in assaults happening. So for example, let me flip to my actual statistics here so I don't give you wrong information. We had in fiscal year 2023, we had 31 assaults among the client population at the Civil Commitment Center, and 12 of those were perpetrated on a staff member by a client. In fiscal year 2024, we had 38 assaults, including 6 on staff with major injuries, including an assault with a deadly weapon.
Thank you.
Is there anyone else have any questions for our resource witness? Thank you very much.
Thank you.
All right. Do we have anyone else who wishes to testify on, for, or against Senate Bill 1610? If not, the chair recognizes Chairman Harless to close on the bill.
I close and ask for favorable consideration.
Thank you, Chairman Harless. If there's no objection, Senate Bill 1610 will be left pending. If there's objection, Chair hears none, and Senate Bill 1610 is left pending.
All right, the chair lays out House Bill 4764 and recognizes Vice Chair Jones to explain his bill.
All right. Thank you, Chairman Harless and fellow committee members for the opportunity to lay out House Bill 4764. We're all familiar with the practice of restrictive housing, often referred to as administrative segregation or solitary confinement. It involves isolating an individual in locked cells, typically the size of a parking lot, for 22 or more hours a day, severely limiting human contact, programming, and sensory stimuli. We know intuitively, and research confirms that there are profound human costs to this kind of isolation. Studies consistently link prolonged solitary confinement to severe psychological harm, including anxiety, depression, paranoia, psychosis, cognitive impairment, and an increased risk of self-harm and suicide. It can also lead to physical health deterioration, including increased rates of hypertension and chronic illness. Unfortunately, while Texas has made progress in reducing the overall number of people in restrictive housing over the last decade, our state remains a significant national outlier when it comes to keeping people in solitary confinement for long periods, often 6 years or more. According to TDCJ's own fiscal year 2024 statistical report, nearly 3,000 individuals were held in what department terms security detention as of August 31st, 2024. Yet beyond these basic counts, detailed routine data to use and impact of this practice is not readily available to the legislature or to the public. The only way lawmakers currently see detailed data is often by filing specific requests. This lack of routine transparency hides patterns and information that we as lawmakers need to effectively oversee this practice and address the serious issue potentially associated with it, like issues around deterioration of mental health outcomes, potential impacts on recidivism and public safety, staffing pressures, and significant financial costs, as restrictive housing units are far more expensive to operate than general population housing. Simply put, if we can't measure it, we can't effectively manage it or ensure it aligns with our state's goals for safety and rehabilitation. House Bill 4764 addresses this critical gap. It requires TDCJ to compile and report annually on a facility-by-facility basis, de-identified data on who is placed in restrictive housing, including demographics like race, sex, and age, for how long they are held, the specific offense or behavior leading to placement, what rehabilitative programs are available, staffing ratios, mental health diagnosis, and a number of other factors. This kind of detailed individual level reporting is precisely what experts and policymakers need to understand the drivers of restrictive housing, identify outlier units and disproportionately impacted populations, and also to assess impact. It is important to note that what this bill also does not do. House Bill 4764 does not restrict CDCJ's operational abilities to place someone in restrictive housing when deemed necessary for safety. It does not mandate a new program or expenditures, and it does not name and shame individuals or officers. The focus is squarely on gathering system-level data and trends to enable informed oversight and evidence-based policy decisions. Members, House Bill 4764 provides the transparency needed to understand and responsibly manage a practice with significant human and fiscal costs. It gives us the dashboard we need to steer a practice that, without this data, risks running on autopilot. I respectfully ask for your favorable consideration, and I'm happy to answer any questions that you may have. Mr. Chairman, I reserve the right to close.
Thank you, Vice Chair Jones, and thank you for the brief layout. Members, are there any questions? Are there any questions? If not,
I like to be thorough.
we're going to reserve your right to close when the chair is going to call up Alicia Costello. We show you registered as Alicia Costello, Associate Director of Policy, Texas Civil Rights Project, and you're for the bill. Is that correct?
That's correct.
You
Yes.
may proceed.
Thank you so much. I'll be brief. Just wanted to share with you all this report that we put together during the interim about solitary confinement and administrative segregation in Texas. Texas is really an outlier on this issue in the wrong way. We feel that solitary confinement is a humanitarian crisis that needs to be addressed. And so we are very supportive of a study done by the TDCJ themselves, given to the legislature in order to study the issue further. Thank you.
Thank you for being here. Members, are there any questions? If not, thank you
Ye-
for being here.
Yes.
Chair recognizes Representative Lowe.
For a question. Hi.
For a
thank-
question.
Thank you again. Let's go back to due process again. You're an inmate, say you got in some fights or whatever, and you got put in the shoe for a while. What due process do you have to earn your way out of that?
It varies depending on the unit, but and it varies depending on your own ability to get access to attorneys or the law library or things. There are many folks who have been released from administrative segregation because they filed their own claims. We represent a client, Dennis Hope, who was in solitary confinement for 27 years, and he was able to get out as a result of his own ability to create his case, talking about how that was not just. So it really varies, but regardless, that's why it's important to take a look at this and understand that there are programs out there that have been used in places like North Dakota and Oregon, where we've been able to actually safely phase out solitary confinement in many instances with no increase in violence or security concerns.
Okay, so I think you answered the question, but let me just ask this. As far as you know, there's no quarterly, semi-annual, or annual review that's automatic for everybody that's confined in solitary confinement.
Not that I'm aware of, no.
Thank you.
Thank you for being here. Members, any other questions? If not, is there anyone else wishing to testify on, for, or against House Bill 4764? If not, the chair recognizes Vice Chair Jones to close on his bill.
Thank you, Mr. Chairman. I close.
Thank you. If there's no objections, House Bill 4764 will be left pending. Are there any objections? Chair hears none. House Bill 4764 is left pending. Members, that concludes today's agenda. I want to say thank you to all the members and all those out there in the audience for their participation. If there's any further business, is there any further business for the committee to address? If not, the chair moves to adjourn. Are there any objections? Hearing none, the committee stands adjourned, subject to the call of the chair.